Good afternoon, everyone. For the purposes of identifying who we are, this is the Senate Judiciary Committee, and the date is January 27th, 2024, and for the record, we have a quorum. We're going to change up the order of our agenda a little bit today. The Minnesota Peace and Police Officer Association, due to the late start of our committee, cannot present today, so we'll have to bring them up at another time. So we will begin with Senator Westlin's bill, Senate File 571. While you're getting settled, I have to amend what I just said. This is the year 2025, not 2024, as I made. So
That is correct.
Senator Westlin.
Thank you, Senator Limmer. Thank you so much. So what we have before you today is Senate File 571, which provides some updates to the Uniform Trust Code. And I do have Lauren Barron here, who is from the Probate, Trust, and Estates section of the MSBA, who's going to be helping me explain this bill to the committee today. Primarily what this bill is mostly technical updates to the trust code, which actually has not been updated for roughly 10 years or so. But I will ask Ms. Barron to maybe help with the walkthrough of the bill so folks can get a handle on what this bill is doing.
Senator Westlin, I believe you might have an author's amendment, the A2 amendment?
Correct. Thank you, Senator Limmer, for reminding me. I do have the A2 amendment. Again, this has a couple of more technical changes to it. And if you'd like me to move that now.
Why don't we move that now? Senator Westlin moves the A2 amendment. It's an author's amendment. All those in favor say aye.
Aye.
Opposed? The amendment carries.
Thank you.
Senator Westlin.
Thank you. And Chair Limmer, I will be deferring to Ms. Barron to help us walk through the bill and explain the changes that are being made to the Uniform Trust Code.
Senator Westlin, did I hear you right that you were having other amendments on the A2 amendment, or is that in proper form?
I believe that this is the proper
All
form
right.
now. Thank you,
Please
Senator.
proceed. Would you identify yourself for the record?
Yes, my name is Lauren Barron. I'm appearing on behalf of the Minnesota State Bar Association for the Probate, Trust, and Estates Law section.
Please proceed.
Thank you. I'm happy to answer any questions as we go forward, but essentially this was put together as a series of changes that were brought together from practitioners in the field of trust and estates over the course of 10 years, studied and determined to be good technical changes to our trust code, which was last amended 10 years ago. So that was the process to get here. There are some ancillary chapters of the Minnesota Code that would also be affected, but all just relating back to the area of trust administration, essentially. The first section here, starting with line 1.12 of the bill, talks about powers of appointment and the rule against perpetuities. This is a highly technical area of the law, but the idea here is to extend the amount of time that a trust may continue before it needs to be fully vested in the beneficiaries. The idea of this is also to make our state more competitive with other states that are doing the same thing. And Minnesota tends to lose out on trust jurisdiction to other states who have already continued down this path. And so I believe it's somewhere in the realm of about 35 states or more that have adopted an extension to their rule against perpetuities. And this is meant to bring Minnesota in conformance with that. Moving on, we have the changes to 501c3, 501c30. I want to make sure I follow correctly here. 501c0301. This is a section of the trust code which deals with virtual representation. So often when you have to do something with a trust, there are unknown, unascertained, or future beneficiaries. And so It is allowed that certain current beneficiaries can represent future unknown and unascertained beneficiaries or minors, beneficiaries who can't otherwise consent. And so these are some adjustments in that area that would allow, essentially expand some of the ability to represent others who can't represent themselves. Moving on to 501c 0411, I believe is the next section that's affected. This is line 4.2 of the bill. We have termination, or it affects modification or termination of a non-charitable irrevocable trust by consent. This deals with the ability for a person who is appointed as an agent under a power of attorney not to be able to modify a trust unless it is specifically a power that's specifically granted to the agent. This actually came up in a court case and was decided by our Minnesota Court of Appeals, I believe, and I believe it stopped at the Court of Appeals, maybe the Supreme Court. But the idea of this change is to be in conformity with what our courts held was the law in Minnesota of how an agent may or may not modify a trust agreement when the power is granted by a power of attorney. Section 501c 0414, the modification or termination of an uneconomic trust. This provision deals with when a trustee may terminate a trust without a court proceeding. So this is meant to take some pressure off of the courts to deal with trusts that are quite small and maybe don't make sense to administer as a trust anymore. It used to be that the limit to do that was $50,000. This would increase it to $150,000. The next section is at line 5.14 of the bill. It is section 501c 0602, the revocation or amendment of a revocable trust. This provision relates back to when the power of attorney may be used to modify a trust agreement and is meant to just be in conformity with the other section on that provision. Line 6.19 affects Minnesota statute section 501c 0605, a limitation on action contesting the validity of a revocable trust. This is a procedure where a trustee may notify the beneficiaries of the existence of a trust and give them a time to challenge the validity of it. It is meant to apply after the settlor of the revocable trust has died. That apparently hasn't been clear in the past, and so this amendment would just simply add that it is meant to be used after the settlor has died. So the settlor is the person who created the trust. The next section is at line 7.8, 501c 0701, accepting or declining trusteeship. The law has provided that when a person is appointed as a trustee, they may accept within a reasonable time, but that was not defined. After looking at various state laws and what other states have done, our committee recommended to allow for 120 days for a person to accept trusteeship of a trust. Otherwise, it would essentially default to the next taker or the next person appointed or the group who might appoint a trustee. Okay, moving down to line 7.26. This is Minnesota Statutes, Chapter 501c 0808. And this deals with a directed trust. So Minnesota trust law allows that whereas you might have a trustee who controls all the investments of a trust, all the distributions of a trust, and holds all the fiduciary powers, it is possible to divide those powers among separate people who serve in different fiduciary capacities. So an investment advisor might oversee the investment portion of the fiduciary duties. A director, a distribution advisor might oversee the distribution duties, et cetera. This entire chapter deals with, this whole section of 501c 0808 deals with those directing parties. The idea of all the changes that are contained here was to bring it a little bit closer to uniform law in some of the different ways that that can be administered, and to generally clarify what are the investment powers, what are the distribution powers, and also to make sure that those parties are always being held to a fiduciary standard unless specifically exonerated from some liability in the trust document. That's a longer section here, so we're going to skip ahead. I believe the next section would start with line 15.18, and if anybody thinks I skipped anything, let me know. Let's see. Oh, I'm sorry, line 14.24. Section 501C 1013, subdivision 4, is amended to show that this has to do with a certain certificate of trust that may be used. So a certificate of trust provides information about a trust that a third party can then rely on to know who the trustee is, that the trust is still in existence. This simply clarifies that a new certificate of trust does not revoke a prior certificate, and anybody's reliance on a prior certificate is still good and valid. Line 15.4, section 501C 1014, amends the section on an affidavit that may be used by a trustee. So in real property transactions, a trustee may give an affidavit to provide certain information about the trust in that transaction, and this would extend that same type of affidavit to be used in personal property transactions. Line 15.12 affects section 501C 1105, subdivision 1. This section is essentially, it deals with how to allocate expenses among income and principal in a estate. This would also include then a revocable trust. So many people in Minnesota use a revocable trust as a will substitute. And when you have an estate, some assets are in the estate and some are in the revocable trust. But at a person's death, it's meant to be administered as a whole. And so this would include the assets of the revocable trust and tell people to follow the same rules in allocating expenses among income and principal. Line 15.18, section 501C 1105. This has to do with, is in the same section of that same bill, defining the decedent's estate to include the revocable trust, and that's how it's all looped in to make the estate one whole between the probate assets and the trust assets. Line 15.23, section 502.851. So now we've moved out of the trust code into the Power of Appointment Act. This is a section that deals with a certain power that is actually granted in a trust instrument. And the section that's affected here deals with a trustee. It's most commonly called the decanting power. And what it means is that a trustee, when they have the ability to distribute trust assets to a beneficiary, can also distribute those assets into a new trust for the benefit of that beneficiary, essentially changing some of the trust terms. And so the changes to this section are meant to bring into conformity mostly with uniform law, the Uniform Trust Decanting Act, some of Minnesota's laws and how that is administered, and the powers that the trustee has to further distribute the assets in trust. There are several portions of that statute that are amended, and so it continues for a few pages in the bill. The amendment that was proposed, if it's helpful to draw attention, comes in section line 20.7, which is subdivision 15 of section 502.851. And what this section deals with are just things that the trustee can't do when they're decanting, things that a trustee might be prohibited from doing. They're meant to prevent foot faults. They're meant to prevent a trustee from changing the terms of a trust in a way that would somehow jeopardize a favorable tax status or put the beneficiary in a position, usually with respect to a tax matter, that would be unfavorable. And so it was just a structuring of the statute for grammatical sense, basically, to take what was an additional prohibition that was stuck in the middle of some of these paragraphs and pull it out to a separate paragraph and make it its own. The last section of the amendment goes to line 22.2. This is Minnesota statute section 524.2114. It is the name of the section is parent barred from inheriting in certain circumstances. This provision is in the probate code and essentially has to do with inheritance, the intestate inheritance of a person who dies estranged from their parent. The idea being that a minor who has an estranged parent, if they died, would not, the estranged parent would not inherit from the minor. But in our law, that changed at age 18, so that same situation, those same people in that situation would reach a different result if that minor died after attaining age 18. So in a situation where they had a parent who had not been paying child support potentially and wasn't part of their life at all, and they never, had a parenting relationship with, if that person dies, if the minor dies, then that estranged parent is disinherited. But it was the fact that after turning age 18, that estranged parent became a taker in default of their deceased person's estate. The change here in the law would bring parity so that those same individuals, situated in the same way, would reach the same result if the person died after age 18. I believe that brings us to the end of our bill. Is that right? Oh, we have, one more section here. Section 524.2804. Is that the same? Nope. This is also in the probate code. Oh, this is a change that falls in conformity with a Minnesota court case that interpreted the probate code. The idea here being that when people are divorced, the law provides that the ex-spouse is disinherited from the decedent's plan, from the decedent's will. So if you had a will that provided for my spouse, then that person would be omitted. If the ex-spouse had died and the plan said something to my spouse, but if my spouse doesn't survive me, then to their heirs, there was a question of whether the ex-spouse's heirs were still included as default takers in the estate plan. And the court interpreted the law to say, no, they are not. The intent of most constituents probably being that if they omitted their ex-spouse, they would have also omitted their ex-spouse's further relatives. This change would omit the ex-spouse's further relatives, consistent with the court decision interpreting this section. I believe that's the end of the bill.
Thank you, Ms. Barron. Are there any questions or discussion on Senate File 571? Any closing comments? Senator Westlin?
Chair Limmer, thank you again for Ms. Barron, also walking us through this bill in detail. It is an area that is not an area of expertise for me, so I certainly appreciated her explaining this to us in layman's terms that were understandable. And again, the last overhaul that the code has gone through was at least 10 years ago, and this is an opportunity to bring the code more current and in some places provide additional uniformity. So I appreciate the committee's consideration.
Okay. Is there anyone in the audience who wishes to speak for or against this bill? Hearing none. Senator Westlin moves Senate File 571 as amended be recommended to pass and move to the floor. Is that correct?
Sure.
All right. All those in favor, say aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Westlin.
Thank you, Chair Limmer.
Thank you.
We have a few minutes, and we can tiptoe into the next half-hour segment. I'd like to move Senator Kreun's bill. He's made promise that he can do it quickly. But as former Senator Betzold once said, we'll be the judge of that, Senator Kreun. So. Senator Kreun.
Thank you, Mr. Chair, members of the committee. It's my honor to present Senate File 202 today before the Judiciary Committee. This has all concerning real property and 3 different sections, if you will, or articles, I should say. The first is the most significant part of the bill, and I do have an author's amendment before we
Senator
get going.
Kreun moves the A2 author's amendment. All those in favor, say aye. Aye. Opposed? The amendment is adopted.
Thank you, Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. The most significant part of this bill is relating to the partition of real property. And before I go too much into the weeds, you might be wondering what partition of real property is. That's simply the division of property among co-owners. And there's 2 principal kinds. There's partition in kind, where the property can be physically divided. Think agricultural land, large parcels of property such as that. And then there's the partition by sale, where the property cannot be divided. And so what this act does is basically to reflect how the parties operate in real life and to bring this Partition Act updated. The last bill we had, I think they said it hadn't been significantly changed in 10 years. With the Partition Act, Mr. Chair, we're looking at the last significant changes to this were in 1905. And so, now that's not always bad with real property. Sometimes the oldies are goodies and the older the better and they don't need to be changed. But in this situation, partition actions were really not very realistic. And during my practice, very rarely used unless it fit a certain type of property. So what does it do? It's more user-friendly. It's more accessible to more property owners. Basically, the order of the partition action was changed. It's more like a traditional court action now. We'll allow there to be 1 referee instead of 3, which is a major improvement. There's more flexible provisions for costs to be paid, which is important. It does give judges in these partition actions a lot of discretion to decide these matters on a case-by-case basis. And a really big change is it allows realtors to be a commissioner, which is in line with how parties would like to currently practice. And the bonus of that is the payment of this commissioner can be the traditional commission that realtors get. So that's a really advance forward for these actions. Another big change is that a physical partition, a partition in kind, was the default under the previous act, and now that there will not be that default. So a partition by sale will likely be a more common availability to real estate practitioners. It provides more structure for the judge to follow, and it addresses everything from how to deal with liens and notification and all those things in quite some detail. And so what this does, Article 1, puts August 1st, 2025 for all actions commenced for the old act, and then this new Minnesota Partition Act for all actions commenced after August 1st, 2025. So that is the partition part of this bill, Mr. Chair. There are 2 other main parts of this. Eminent domain is in Article 3. This is largely a procedural matter. It's designed to provide certainty to capture the universe of the people who need notice in these proceedings. There could be multiple reports in one action, and practitioners should only have to serve the parties who have an interest in the parcel subject to that report. And there was some ambiguity in the existing law. This provides clarity and certainty. Then there's some conforming language after that. Finally, the last article, Article 4 in here, deals with transfer on death deeds. This was recently before our committee, and there were some changes that went into effect. And the whole purpose of those changes is to avoid probates. So if, for example, you have 3 joint tenants and one dies before the grantor dies, does the whole thing lapse? Do you need a probate, of the grantee? These these are designed, these vehicles are designed to avoid probate, and when someone predeceases the grantor, then the remaining joint tenants should take it all. Now, that part that was before the committee before was supposed to be retroactively applied. It was not. So that fixes the oversight here, and it also makes sure that the insurance coverage question, that was really the main point of what we discussed before this committee last time, is not retroactive, and that was, really important here. So the Insurance Federation knows about this, hasn't opposed it, because we're not changing that aspect of it, which was negotiated the previous time we were here. And thanks to Senate Council, we have a draft here that we think gets at that intent. So that's my summary, Mr. Chair, and I'd like to now turn it over to my testifier, Kevin Dunleavy, who has, I don't know how many hours he's testified down here at the legislature on real property bills, but he's been a real invaluable service for many years, educating legislators on the importance of real estate law. So, and he also happens to be my boss and law partner for 16 years before I was in the Senate. So it's a real honor to have him next to me testifying in favor of this bill.
Mr. Dunleavy.
Mr. Chair, committee members, apparently I didn't yell at Mike too much, Senator Kreun too much when he worked with me, because we still are friends. And his testimony today, though, he didn't leave me much. There isn't much to add to it. I think the Partition Act is going to be a lot better than it was. It was really difficult to use in the past, and I think this will make it much easier and less expensive for people to do partitions. The eminent domain thing also makes it more clear and less expensive for the participants in an eminent domain action, so that you don't have to give notice to everybody. You could have 100 parcels or 500 parcels, and there's only one that's on appeal, then you only have to give notice to the people involved in that particular parcel. And in transfer on death deeds, I have to apologize, Senator Limmer, and to the committee that I didn't catch this last year, but I'm glad we're taking care of it this year. Thank you.
Thank you, Mr. Dunleavy. Are there any questions from the committee members? Is there anyone in the audience who wishes to speak for or against this bill? Hearing none, Senator Kreun moves Senate File 202 as amended, be recommended to pass and move to the floor. All those in favor, say aye. Aye. Opposed? The motion passes. The agenda is now fulfilled as far as we can push it today. We'll be getting back to you regarding testimony from Minnesota Police and Peace Officers Association when they can come later. Senator Latz, do you have any comments? We stand adjourned.